Good morning and welcome to the Husch Blackwell Labor Employment Virtual Seminar, Colorado Update. I'm Shauna Ritz and I will be your moderator today. I am a senior associate here in the Denver office of Husch Blackwell and part of the Labor and Employment Group. Before we get started, I'd like to cover a couple of housekeeping matters. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit those questions via the question box. We will respond to the questions during the webcast as time allows. A PDF of the presentation and other resources are available in the resources folder. A PDF of the presentation and other resources are also available in the resources folder. This program has been approved for HR and legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Towards the end of the program, be sure to complete our short survey. We will use your feedback to plan for future programs that are applicable to your business needs. And this is all for the housekeeping items, so let's get started with our program. First, I will give you an overview of the agenda and the speakers that you will hear today. We have 4 sections that we'll be covering over a 2-hour period. Please sure to take a break as needed, as we will not have any formal breaks within the program. First up, we'll have Chris Otley presenting on vacation PTO, use it or lose it policies, and the Nieto versus Clark's market decision. In the second section of our program, Barb Grandjean will be providing an update on Healthy Families and the Workplaces Act, and Ashley Jordan will discuss Colorado's Family and Medical Leave Insurance Program. In our third section, Chris Otley and Owen Davis will be covering the Colorado Equal Pay for Equal Work Act 1 year later. And last, I'll be presenting an overview of the 2021 labor and employment legislation here in Colorado. All right, first up, we have Chris Otley covering vacation and PTO, use it or lose it policy. So I will turn it over to Chris.
Thank you, Shauna. As Shauna mentioned, I have the opportunity to speak today about the Nieto versus Clark's market decision. For those of you who've been trying to pay attention to the Colorado major developments that we've had in employment law in the last year, this probably does rank right at the top. Part of that is because the legislative activity was a little bit less pronounced in 2021 than, say, in 2020, where there were some really major pieces of legislation that were passed and that we're providing updates on. But also because the decision that was issued by the Colorado Supreme Court was a very impactful decision. Frankly, it's one that many people in the employment law community, both on the plaintiff side and on the defendant side, had anticipated would be coming out at some point, whether it be this past year or whether it might have even been earlier than that. It was a topic of frequent discussion. So with that, let me go ahead and get into it. I'll just preface all of this by saying that this is a topic that I've been following closely, not only as an employment lawyer in town, but also as someone who actually participated in a tangential way in the decision-making. I represented 3 different business groups who submitted an amicus brief to the Colorado Supreme Court. As you'll find out that as we go through the presentation, my amicus brief had almost no impact whatsoever. And in fact, there was a unanimous decision on the Colorado Supreme Court that rejected many of the arguments that we made in the brief. I'm actually going to walk through a little bit of the reasoning to the brief, not only for our brief, but also the ultimate Supreme Court decision that Justice Hart issued. I can't say the decision was a complete surprise, except for in one respect, and that one respect was just how sweeping the decision was. I think there's probably a more narrow way for the Supreme Court to have addressed that. So first topic is, what is use it or lose it policies? Let's just make sure we're on the same page. Many of you on this video conference right now are in HR or have a legal function with employment law responsibilities. And you're probably very familiar with what a use it or lose it vacation policy is. What it in effect says is there's really kind of 2 variations on it, but very similar. It basically tells employees that vacation, the purpose of vacation, is so that employees take time off during the year, and that they can use that time for personal reasons, to go on vacation with family or friends or whatever they want to do. It is not at all uncommon for companies to have vacation policies. It's not at all uncommon for executives to have within their employment agreement, some sort of provision for vacation. And sometimes both those agreements or those policies will say something to the effect of the employee is required to use their vacation during the year, and if it's not used at the end of the year, only some small portion of that will be carried forward, or no portion of that will be allowed to be carried forward. The two variations that I wanted to refer to are, one, there's kind of a use or lose it policy for current employees. In other words, an employee who has not been separated for their employment. The question is, are they allowed to carry over, excuse me, some portion of the vacation? Secondly, there's also the issue that's a little bit more pertinent, and it was directly addressed by the Clark's Market decision, and that deals with what do we do with vacation that has been earned but not used at the end of the employment relationship. The Colorado Wage Act, which has been around for several decades, I think going back even into the early part of the 20th century, has always maintained that employees would be able to bring suit in the event that they're not paid out any wages that they had earned. In 2003, the law was passed, and in that, when that the law was amended, and with that law that was amended, we saw this provision that was added to the Colorado Wage Act. Colorado Wage Act now provides that vacation pay is considered wages. Generally speaking, almost every state in the country has some provision that provides that under their Wage Payment Act, that wages must be paid out to an employee. And there's usually provisions about when the payment can be made and what's the form of the payment and things like that. There's also almost always going to be a provision like what Colorado has, which is to say at the end of employment, when there's a separation of employment, there's going to be a requirement that the wages that have been earned and unused have to, or excuse me, that have been earned have to be paid. The question that was addressed by this legislation in 2003 was, what about vacation? If somebody has earned their vacation and they haven't used it, does that get paid out? Well, the law was passed that said, in effect, that yes, that vacation is considered wages like anything else. And I want to read the language to you so you're aware of exactly what the Colorado Wage Claim Act says. If an employer provides paid vacation for an employee, the employer shall pay upon separation from employment all vacation pay earned and determinable in accordance with the terms of any agreement between the employer and the employee. And there's two sections I want to really focus on there. The first section is right before I put it in bold, which is to say something that's been earned and determinable. What does earned and determinable mean? I don't think we need to look up as fancy definitions within Black's Law Dictionary. I think we know what earned and determinable means. It means, in effect, earned means that the employee has actually earned it according to some schedule that's been provided by the employer. And determinable means that it's not subject to speculation, that it's clear, it's definite, it's something that's that both the employee and the employer can decide what the amount is. What's interesting here about that section, earned and determinable, and became a very big issue in this case, is that there is no term vested. And the reason why that's such a big deal in this case is because wages in general in Colorado were defined as earned, vested, and determinable. So what did the General Assembly mean in 2003 when they omitted the term vested? Was that just the Scrivener's error? Was that just a mistake? Or was that intentional? Was there a reason why vested is no longer within that within the phrase, the payout of vacation at the end of employment? The second portion of this provision that I want to make sure everyone's aware of is really kind of the key provision that we are fighting about here while this case was pending. And specifically, it said in accordance with the terms of any agreement between the employer and employee. Now, I have always advised employers that the way to look at the Wage Act, and this is true for both federal and state wage act, is that they are in effect just breach of contract claims with certain enforcement mechanisms. In other words, generally speaking, an employer and employee can come to an agreement on the terms of what the wages are going to be, and if it's written down and it's reasonably clear, the terms of that agreement will then determine what is the payout. So in other words, employees, generally speaking, don't get to bring claims against employers for saying that they're owed money more than what's already been agreed to by the employer and the employee. They're usually stuck with the terms of the agreement. And I think for many years, people in Colorado, and I'll go through a little bit about what our previous understanding of what this rule was or what the law was, is that they looked at this provision and they said, that's just codifying what we already kind of knew, which is that the Wage Claim Act just enforces the agreements between employers and employees. And except in the most egregious circumstances, it's going to be enforceable. They looked at that in accordance with the terms of any agreement between the employer and employee as the operative words within that provision to decide what employees get paid out for vacation. Well, under use it or lose it policies, there was generally speaking a understanding, I think, in the employment law community here in Colorado, that an employer could have a use it or lose it policy. And if you think I'm pushing too hard here because maybe the plaintiff's bar doesn't agree with me, I'm going to point out that the Colorado Division of Labor and Employment had issued guidance in 2014 that specifically said use it or lose it provisions in a vacation agreement are enforceable. On this slide that I just advanced to, this is guidance from a frequently asked questions document that was published by the CDLE, and I'm quoting it here. This is not my language. This comes directly from the division of the Colorado Department of Labor that's charged with enforcing the Colorado Wage Claim Act. And as recently as 2016, this guidance was in effect. And again, this is during, regardless of the kind of the political administrations, Republican governors, Democratic governors, the general guidance we received from the CDLE was that you could have a use it or lose it policy as long as it was included within the terms of an agreement between the employer and the employee. Now, it didn't fully answer the question because there wasn't exactly clear language about what is earned and what is not earned. Nonetheless, I'll also say that there were multiple decisions from the Colorado Supreme Court and the courts of appeals, and even more so from the trial courts, that made clear that basically the Colorado Wage Act enforced policies as they were written. If a policy said that is use it or lose it, that was going to be enforceable. Well, there was a wholesale change in 2017. The CDLE issued new regulations. They provided new guidance that completely reversed this previous guidance. And employers were then kind of stuck with saying, well, is that going to even be enforceable? Because then obviously that raises kind of an interesting question of if just because the CDLE changes its mind, does that mean that it's going to be enforceable? Well, with this background, many employers had these use it or lose it policies. And I'm going to move forward now to what this case was that was at issue before the Supreme Court. So Clark's Market, which runs the grocery stores, had a woman by the name of Miss Nieto, who had been an 8.5-year employee. She lost her job. And in fact, I actually don't know the reason why she lost her job. I don't know if it was misconduct or showing up late or poor performance. It could have been any number of reasons. But when she lost her job, and I believe it was in 2016 or 17, she lost her job. She had about over 100 hours of unused vacation that she sought to claim. And she was an hourly employee. This wasn't a huge sum of money. It was like, several $1,000s, but it wasn't a large sum of money. And she sought to have that paid. The company refused. She issued a written demand after obtaining an attorney. The demand was denied. She then filed a lawsuit. And the employer in this case, Clark's Market, they filed a Rule 12b-5 motion. For those of you from out of state, a 12b-5 motion is nothing more than a federal 12b-6 motion. It's a motion to dismiss for failure to state a claim. The argument was you can look at everything in the complaint and see that she's seeking a payout of her vacation when there is a policy that has been written that said that she was not going to receive her vacation. And I'm going to go ahead and read to you what was in the company's handbook that explained what was to be paid out to all employees at Clark's Market. This was not an individually negotiated agreement between she and Clark's Market. This was their standard handbook. And it said, in the event you voluntarily leave Clark's Market and give at least 2 weeks written notice, you'll receive vacation benefits earned as of your last anniversary date, but not taken by the date of your separation. If you are discharged for any reason or you do not give proper notice, you will forfeit all earned vacation pay and all earned vacation pay benefits. That was the way the Clark's Market was trying to enforce. This was the policy that they had placed in the handbook. I'll just tell you from someone who's written a lot of employee handbooks, this was going to be a tough one to defend. Even under the old understanding, under the Colorado Wage Claim Act, this was going to be a tough one to defend. And there's 3 reasons why this was a tough policy. First, notice that this was in a handbook and it wasn't in an agreement. And this is something, by the way, that came up during the oral arguments for the Colorado Supreme Court when the case was being decided. It was not a part of the final decision, but it did come up at oral arguments. Generally speaking, employee handbooks have a big disclaimer right at the front that say this is not an agreement. this can be revised, or modified by the employer without notice, without consideration, without consent of the employees. And because there's that big disclaimer, there's always a big question mark, both on the plaintiff side and the defendant side, about whether you could have just an employee handbook that captured what was going to be considered an agreement, quote unquote, because that's the language that's used in the statute. And the answer for most of us was a big, who knows? We weren't quite sure how that was going to play out. Many of us on the defense side started drafting separate vacation agreements specifically because, generally speaking, employer policies are not considered an agreement. The other thing that was difficult about this language, and it was my hope that if the Colorado Supreme Court was going to rule against the employer in this case, they were going to pick up on this, as the language within this agreement very specifically talked about forfeiting earned vacation pay. Using the term forfeiture or forfeit is very dangerous in wage and hour law. That's language that goes back to the very earliest days of wage and hour law, both under the federal law and under state law. To say that an employer was going to cause an employee to forfeit earned pay, that made it even doubly worse because earned comes straight from the Colorado Wage Act. This was going to be a problem. But let me tell you the biggest problem, and that's the third one. The third one I have listed here is that it was forfeiture upon involuntary termination. In other words, so long as the employee complied with the policy and provided 2 weeks written notice, they would get their earned vacation pay. But under this policy, the employer could say, well, actually, in this case, I don't want you to do it. I'm going to fire you, and that way you don't get your vacation. It provided the employer with a level of discretion that I think that the Supreme Court was extremely reluctant to focus on. Generally speaking, the Wage Act is considered to be a remedial statute, a statute that's there to provide a remedy for employees who don't have the same bargaining power as employers. In this case, what Clark's Market was attempting to enforce was a rule that an employer could terminate an employee, discharge them for any reason or no reason at all under standard at-will employment rules. And in that case, they had the discretion to decide whether an employee would receive their pay. That did make its way into the opinion that was issued by the Colorado Supreme Court. Because the Colorado Supreme Court talked about how the entire purpose of the Wage Act was to avoid oppression and fraud. You know, when you start off with the language of oppression and fraud and assume that that is the purpose of the Wage Act, that the employer is going to have a tough time enforcing that. When I was drafting my amicus brief to the Colorado Supreme Court, I was really hoping, and by the way, I drafted that with our former colleague, Stacey Bowman, I was really hoping that the court would focus on that more narrow issue and not on the broader topic of, are use it or lose it policies okay? Well, I lost on that front as well. The holding of the decision ultimately is, and I won't read the entire language to you, but I did provide it in the side so that you have it. But in effect, it says that all vacation pay that is earned in Determinable must be paid out at the end of the employment relationship. And I can walk you through all the statutory tools of interpretation that the court used. The court decided that there was an ambiguity, specifically with respect to whether was there a difference between earned and determinable and earned vested and determinable, what that sort of language worked out. But the net effect of all this is that Colorado now is one of several states that is going to prohibit the use of use it or lose it policies. Now, if you remember at the beginning of my talk here, I said that there's kind of two different types of use it or lose it vacation policies. There's no question that the second type is absolutely prohibited under Colorado law right now. The second type being that employees at the separation of employment cannot lose any unearned vacation pay. However, I think you would be naive to assume that the first type of use it or lose it vacation policy is okay. And the first one deals with continuing employment. When an employee has some provision within their policy or an employer has some provision within their agreement that says employees that are in effect that will lose any unused vacation or will only be allowed to roll over a certain amount, that would be enforceable any longer. I think it's fairly clear that that's not going to be enforceable in the language of this rule. There's some statutory reasons why we might be able to make a distinction between payout at termination versus just continuing employment. You'd have to be very tolerant of risk as an employer to assume that that's going to be the case going forward. So, with this, there was still one big outstanding question, which is what about PTO? Most companies, I think a majority of companies now do not provide explicit differences between vacation pay and sick pay. They combine it all into one called paid time off or PTO. And it all has different names and use, but it is in effect companies don't want to get into trying to decide why are employees taking their time off work, whether it's because they're sick or whether it's because they're going on vacation or whether it's because they just want to do something, take a personal day. Generally speaking, most companies were very comfortable with having a catch-all provision for PTO. Well, as I mentioned before, the CDLE used to issue one form of guidance on use it or lose it policies, and they also used to provide informal guidance on whether or not PTO must be paid out at the separation of employment. And the answer we received from the CDLE on an informal basis was always, because PTO is a combination of both sick leave and vacation leave, that PTO would be treated than just straight vacation pay, that PTO would not be subject to that payout. Again, you'd have to be very naive to assume that that rule was going to be upheld after the Clark's Market decision by the Colorado Supreme Court, which, by the way, was unanimous. So Justice Hart was speaking for all 7 justices when she issued the ruling that in effect banned use it or lose it policies. The question next was, what about PTO? Well, the Colorado Division of Labor and Employment decided to issue a new rule. And the new rule that it issued is this. Under Nieto, it pointed out that all vacation, and that's their emphasis, all vacation pay that is earned in a determinable must be paid. And so vacation pay under this rule is to pay for leave regardless of its label that is usable at the employee's discretion, other than procedural requirements such as notice and approval of particular dates, rather than leave usable only upon the occurrence of a qualifying event. For example, medical leave, caretaking requirement, bereavement leave, or holiday. What this rule is very clearly intended to address was this open question of, what do we do about PTO leave? And the answer is, now PTO leave must be treated the same as all vacation leave because it contains a component of vacation. And so what the CDLE with this rule is attempting to say is, how do we determine whether or not it's going to be vacation or something else? It's going to be looking to this idea of an employee's discretion. Does the employee have the right or the choice to take the day off for whatever reason? Sick leave, personal leave, holidays, you name it. The question is going to be, is there a discretion associated with it? If that is the case, then that is going to be treated as vacation and it needs to be paid out. Now, something that Barb Grandjean is going to focus on is my last bullet point on this slide here, which is under the Healthy Families and Workplaces Act in Colorado. There is a large question about whether or not a company is able to meet all the requirements under the sick leave minimum allotment of 48 hours per year with PTO. The answer, generally speaking, is yes, which was obviously a benefit for employers, particularly those employers that were using PTO. However, now that PTO is treated as vacation pay, employers might actually have less of an incentive to actually be offering PTO. And it creates an interesting dynamic for the company. So now that we know that vacation must be paid out, regardless of whatever any policy says or any agreement says, now that we know that PTO is considered the exact same as vacation, the question might be open to interpretation of, well, what's left? What are employers allowed to do with respect to vacation and how they structure their vacation? Because I'll just tell you from experience, it's usually not HR departments and legal departments that are most concerned about accrued vacation sitting on the books that an employer needs to pay out. It's usually someone from the finance departments, the CFO, the controllers, et cetera. They're the ones who are going to look at this and say, this is a liability on our books and we want to minimize it in some way. How do we reduce what we can do? Well, there's a number of items that an employer can still approach, and everyone on the employment team here at Husch Blackwell has been focused on these sorts of choices that an employer will make. Some of them are on the safe side, some of them are on, it's plenty safe as long as you get advice side. I put a little asterisk there by call us if you want to implement any of these policies. And I'm just going to start in the upper left-hand corner. So the first question, or the first issue that employers have about in terms of their discretion is whether to offer vacation at all. There is no law requiring employers to offer vacation, including in Colorado. If employers choose to withdraw the vacation benefit in light of these decisions, it is entitled to do so. There's obviously going to be major repercussions within the morale of the workforce, and whether that's something that's acceptable to, particularly in a time when we have low unemployment and it's a difficult time finding jobs, But if that is a choice that the company needs to make or feels like it should make as a result of these decisions, it is absolutely permissible. There's no question about that. Even Justice Hart's decision emphasized that over and over again. If a company offers vacation, it needs to comply with these rules, but it is not required to offer vacation. Somewhat relatedly, many employers are starting to move, at least for exempt employees, into what's called a flex policy, or the idea that employees will not even be provided a specific allotment of vacation. Doesn't mean they can't take vacation. It just means that we're not going to have some specified amount that needs to be accrued, that needs to be tracked, that needs to be taken care of at the end. I personally, for example, have never had a vacation allotment ever since I became a lawyer, because it's very common for law firms just to assume that they don't need to keep track of their associates' pay or taking use of vacation time, in part because we all know that they often have to work during their vacation. If you're going to implement a flex policy, let's talk. The real issue there is if you're doing the transition from a vacation policy to a flex vacation policy. One big word of caution there is do not call it unlimited vacation policy. That is the exact opposite of what you're trying to accomplish. Employees, last time I checked, were hired to work, not to take unlimited amounts of vacation. It's a flex policy that leaves it up to the discretion of the employee to schedule their vacation time so they don't have a payout. Third area that the employers have discretion on, similar to not being required to provide vacation, is the absolute discretion to decide how much vacation there's going to be. If you're seeking to provide PTO to cover sick leave, in Colorado, you are required to provide the 48 hours of sick leave, as Barb's going to go into a little bit more, but you're not required to provide any minimum amount of vacation. Same thing with the accrual schedule. Some employers like to keep it easy. They give a one lump sum batch of vacation to employees on January 1st, and that's going to last the employees throughout the entire year. If the employees leave and at the end of January, there will be usually a payout because they probably haven't used all of their vacation. Other employers like to have a very specified schedule, for example, 1 or 2 days a month or 1.66 days per month, depending upon the seniority of the employees. That is something that employers still have complete discretion to do. The most likely response to these decisions that Colorado has had, both the ruling from the Division of Labor and Employment, as well as the Clark's Market decision, is that employers are allowed to implement a cap. The cap would say something along the lines of employees are not allowed to accrue more than 1.5 year of their allotment of vacation per year. What that's going to do is limit the amount that the employee is going to earn under their policy. The policy needs to be very clear. It needs to be written in a way that employees understand it. If a cap is implemented, employees cannot forfeit what they've earned before that in the event that they have more than their cap. But that's a justifiable, defensible way for employers to limit their exposure. I mentioned 1.5 times. It can be less than that. It can be more than that. The cap is one of the more straightforward ways for employers to at least have a predictable amount of unused vacation time on their books. The last two are the ones that really kind of become the most difficult for employers to adjudge. The first one is the forced use. Forced use is, as the name would imply, is employers are looking sometimes to require their employees to take vacation that's been allotted to them. I did put an asterisk on there, and I put an asterisk on there because I want you to talk with me about it before you do it. First, we need to look at your policy. Second, we need to understand how that, if you are going to require employees to use vacation, how that's going to be done to minimize any sort of morale issues. Many employers that are looking at employees with lots of accrued and unused vacation may say to the employee, you're going to be required to use that vacation or PTO time within the next 6 months or within the next 3 months. The less discretion you give to employees, the more likely they're going to be to push back. And so if you're going to require employees to use the vacation they've been allotted, then you need to do it in such a way that you give them some ability to choose when their vacation is going to be spent. Because chances are that's been the history of vacation. Sure, vacation usually has to be approved by a supervisor, but if you're going to force an employee to use it, it's probably a departure from your previous practices, and you need to talk it through. My general suggestion to employers that have been doing this is to give employees as much heads-up notice ahead of time that they need to start using their vacation. Employers have a really good reason for mandating the forced use, by the way. The idea of vacation pay is not that it's going to be severance payment at the end of employment. The idea of vacation is that employees are going to take the time, going to recharge their batteries, they're going to have some time off, they're not going to get burned out, and they're going to be more productive employees as a result. The idea of vacation is not that once they leave, they're going to get a really large lump sum payment to help out the transition to the next job. And I think that is kind of how the idea of Clark's Market and some of these other rulings that have come out, I think there is kind of a sense that, well, that's what they're owed. I do think, though, however, that employers do have the ability and the discretion to say otherwise. And finally, a buyout. So, for example, if you're an employer that wants to switch to a flex policy, sometimes the easiest way to do that, because employees, again, can't lose any earned vacation time that they already have on the books that hasn't been used, one way to accomplish that is a buyout. The buyout would literally be paying employees for the equivalent of whatever vacation time they've used. You'll want to evaluate what your policies are. You're going to want to look more broadly at how that's going to have an impact on the workplace. And you're going to want to, again, have some sort of heads up fair notice to the employee. So very similar to forced use, kind of flip side of the exact same coin. So either way, the one thing I always tell employers about wage and hour law, and it's somewhat ironic, that under wage and hour law, there are extreme circumstances where there are really bad actors. Those bad actors oftentimes might be in the agricultural industry or maybe the restaurant industry or some other industries where there's a lot of low-wage workers. And in the past, employers have mistreated employees. And I'm not pretending as a defense attorney that there aren't instances where there have been employers who have misused vacation in the past or wages. But those bad apples, as rare as they are, really guide all of wage and hour law. Wage and hour law is not directed at your standard employment office environment with white-collar workforce where employees are attempting to work out with their employees who gets paid what, for example, under a commission policy. But unlike, say, discrimination law or retaliation law, there is no good faith defense associated with wage and hour violations. If a company has violated their wage and hour laws, they can really make big mistakes, and those big mistakes are expensive. There's penalties associated, there's federal laws, there's state laws, there's the potential for collective action. And so what I would try to remind employers is that because it is, in effect, a strict liability standard that's governing employers, is you do need to tread very cautiously. And so this vacation decision had such a major impact because so many employers who were operating in good faith under the previous guidance from only 5, 6, 7 years ago under the CDLE, they found out that their policies were no longer enforceable and could actually subject them to liability. And so one of the things that we always want to do as employers is, and particularly as we're advising employers, is whenever you make a big change to anything related to employment law and to wage and hour law, do so cautiously and with advanced notice and planning. If you don't do that, you're likely to end up in a situation where there would be some significant liabilities. So call us first before you make any major decisions, recognizing that on occasion you're going to have some problems. With that, I'll turn it back to you, Shauna.
Great. Thank you so much, Chris. That was great information and perfect timing on your part. Now we're going to do a couple poll questions that you should see pop up on your screen. The first poll question is, what type of time off policy does your company use? Your choices are vacation pay, paid time off, or neither. We'll give you just 30 to 45 seconds to go ahead and put an answer in, and I will update you with a tally as we see those responses come in. All right, it's looking like definitely leaning towards paid time off at about 58%. Vacation pay at about 38%. Great, that's great information. All right, we're going to move to the next poll question, and this is a bit of a follow-up on some of the things that Chris touched on. As we discussed, there is likely going to be a change in PTO being treated like vacation time. So if that change happens, which of the following is your company likely to consider it if the prohibition on use it or lose it applies to PTO? Will you impose accrual caps on the PTO? Will you switch to a flexible time policy off, which is going to be unlimited time off? Neither, or another type of policy? Wow, this one is almost unanimous for a minute. It looks like most people are leaning towards imposing a cap on PTO if these new policies go into place. Great. All right, well, we're going to move on to our next section. I'd like to introduce Barb Grandjean and Ashley Jordan. Barb is going to be providing us with an update on the Healthy Families and Workplaces Act, And Ashley is going to be giving us an overview of the Colorado Family and Medical Leave Insurance Program. So I'll turn it over to Barb and Ashley.
I know Chris thought that his presentation was the really interesting one. Ashley and I are going to give a more interesting presentation than the last one, so stay tuned. I am going to start with the Healthy Families and Workplaces Act, referred to as HFWA. This was signed into law what seems like years ago, in July of 2020. And you may recall that in 2020, it required all employers to pay all employees in Colorado for COVID-related time off. And that was a short-term pandemic paid sick leave provision. I'm really interested to hear, if you'll add to the chat, some of the issues that you have run into in 2020 and then into 2021 about how you've used HFWA and some of the challenges that you've had in managing that. So in 2021, then, the regular paid sick leave provisions started. If you had more than 16 employees starting January 1 of 2021, you were providing regular paid sick leave. This is a reminder that if you're a smaller employer that didn't have to do that in 2021, you do have to start doing that January 1st of 2022. So at that point, in Colorado, all employers of any size will have to allow their employees to accrue regular paid sick leave. As I mentioned, HFWA also had these public health emergency paid sick leave provisions, and they started for all employers as of January 1, 2021, regardless of size. And the public health emergency paid sick leave stays in place during the entire duration of the public health emergency. It's not accrued, it's just a bucket of paid leave that's provided to an employee during a public health emergency. And it has to be available till up to 4 weeks after the emergency ends. I'll come back to that one in a minute. Then also just a reminder on the accrual issues of paid sick leave. The regular sick leave accrues for 1 hour for every 30 hours worked, up to a total of 48 in a year. The public health emergency paid leave is a supplemental bucket that's provided as of January 1, 2021. But in April of 2021, CDLE clarified that it also is a bucket that springs into life when an employee is hired. So if you hired an employee of May of 2021, that employee would have been entitled to up to 80 hours of public health emergency paid sick leave upon the date of hire. There was some confusion this summer as Governor Polis lifted the state of emergency in Colorado, and there were some writings that indicated that that meant that the public health emergency paid sick leave in HFWA was no longer in play. CDLE has clarified that that is not the case, that the public health emergency paid sick leave has to be made available through the entire duration of a state or federal public health emergency. The federal government has indicated that its state of emergency is going to continue until at least January of 2022. So according to CDLE, the earliest possible end date for a Coloradan to use HFWA public health emergency paid sick leave, the earliest end date is going to be February 13, 2022, which is 4 weeks after when the federal health emergency is anticipated to end. Remember, again, that the public health emergency paid sick leave is simply a bucket. It does not replenish. And so if you have employees that during 2021 have used the public health emergency paid sick leave for COVID-related reasons or school closures or care for family, that is no longer available to them, but certainly their regular paid sick leave is available for COVID reasons. You use the public health emergency bucket first, but then you move to the regular paid sick leave bucket. So again, this slide is a recap. It's very dense. I'm providing it for your information and reading later. But it's a reminder of the reasons why your employees can use either the regular paid sick leave or the public health emergency paid sick leave. It covers preventative, care, diagnosis, and treatment, which is something that we'll come back to in a few minutes. But what I think is important, and the point that I wanted to make in this seminar, is that we've had issues come up during the year where you have someone who is perhaps not vaccinated or is what I would call a party person. So they haven't really been listening to the guidance about social distancing and staying away from large crowds. This statute, this paid sick leave statute, is a benefits statute. It is not a conduct statute. So if you have your party person employee who is always out in crowds and seems to always be under some sort of quarantine or other exclusion from the office because of their conduct, CDLE has made it clear that you are still obligated to pay the public health emergency sick leave for those individuals. And at first blush, it seems unfair that somebody's own lifestyle choice could result in additional paid time off, whereas someone else who's maybe doing all of the right things and staying safe doesn't need to quarantine and they don't get to use that public health emergency paid sick leave. Unfair or not, again, it is a benefit statute and not a conduct statute. And so you can't exclude somebody from using paid time off, even if it's perceived to be sort of their own fault that they need the paid time off. So here's where it gets interesting. We are obviously closely watching, as I'm sure many of you are, the vaccine mandates that are floating around, many of them tied up in the court system. CMS has issued a mandate for healthcare providers. There's a federal contractor mandate. The one that probably most of the people on this webinar are thinking about is the OSHA ETS. I would call that a large employer mandate. So any employer that has 100 or more employees either has to adopt a hard mandate, which would require all employees to be vaccinated or have a valid religious or medical exemption granted, or OSHA allows and recognizes what would be called a soft mandate, that the employer can encourage vaccination, but an employee can choose to test out, basically be tested and wear a mask without having to articulate a religious or a medical exemption. In the OSHA ETS, OSHA has made it very clear in its opinion who should be paying for certain components of this program that OSHA is recommending, and the payments are intended to incentivize certain behavior. So for vaccination purposes, if you're not under any kind of a mandate at all or an anticipated mandate, then HIFWA would indicate that you could use public health emergency or paid sick leave for someone who needs to get vaccinated or who chooses to get vaccinated during work hours. Now, if someone decides they're going to get vaccinated on a Saturday, you're not paying them paid sick leave for time that they were not otherwise already scheduled to work. Under the OSHA ETS, if this passes, and for the employers that it covers, the employers are obligated to provide up to 4 hours of paid time off to get the vaccine during working hours. And OSHA is clear that this is intended to incentivize employees to get vaccinated. So they're allowed to do it during work instead of on their personal time, and they're going to get paid for up to 4 hours of doing it. However, OSHA has also indicated that in order to further incentivize this, they don't want employers to use or require the employee to use accrued vacation or sick time to get vaccinated. Because then an employee might say, well, I'm not going to get vaccinated after all because I want to save this time for my upcoming vacation, or I want to save my paid sick leave because, you know, I have a kid that brings home all kinds of germs and I know I'll need it. So OSHA does not want employers, it prohibits employers from using accrued paid leave to offset the 4 hours. Additionally, the OSHA ETS would suggest that employers need to pay for reasonable time for an employee to recover from the side effects of being vaccinated. And OSHA has indicated that that's roughly 2 days. That provision, that can be offset by paid sick leave or PTO. So if we take the 4 hours for vaccination and think of it in the context of HIFWA, it might suggest that you can't use the public health emergency paid sick leave to offset the 4 hours that you have to pay someone in order to get vaccinated under the OSHA ETS. I would argue that that's not necessarily the case. Everything is gray right now with the vaccines, but OSHA does talk about not allowing an employee to use accrued leave. As I've mentioned before, the public health emergency paid sick leave is not accrued. It's a bucket of time off that springs into effect because of the public health emergency. And so I would argue that that is should be available and should be used for an employer who has to pay for an employee getting vaccinated for the 4 hours. Don't take that to the bank. Everything does change. If the OSHA ETS passes, we may be seeking some clarification on whether or not those 4 hours can be banked against your public health emergency paid sick leave. Certainly, if your employee does not have any public health emergency paid sick leave, and all they have remaining is the accrued regular sick leave, then you do have to come out of pocket to pay the additional up to 4 hours. HIFWA and testing, again, if there's no mandate, you can use the HIFWA time off to pay for an employee who gets tested during the work hours. And the OSHA ETS doesn't change that. So an employer doesn't have to pay for the testing if an employee chooses to test out as part of a soft mandate rather than getting vaccinated. There is still a question. OSHA purports to preempt any state rules that are different than what OSHA is suggesting. But in this case, I think because the HIFWA paid time off is actually of benefit to the employee, the question will be whether OSHA wants to prevent shifting the final financial burden to the employee, if that's enough of a reason why OSHA would try to preempt the Colorado HIFWA. So I'm nearing the end of my time. Let me finish up these last couple of slides. I think probably the biggest problem that I've seen with HIFWA during 2021 are the employers who have chosen to embed HIFWA into a PTO policy so they don't have to give extra time off. Under HIFWA, the employer has to be able to track and report paid sick leave, accrued and available. And so although it may be PTO time, you still have to find out why your employee is taking time off and ascertain whether it is for a regular sick leave reason or a public health emergency paid sick leave reason. So I think that in the context of what Chris has explained with the changes to PTO and vacation, employers need to be thinking about whether they want to stick with a PTO policy versus a separate vacation and sick policy. Under the PTO policy, they're not providing any additional time off, but implementation and record keeping is extremely complicated. Under a sick leave policy, I think your employees are going to perceive that you're taking time away from them if you split out a PTO into sick and vacation. They're going to feel like they're losing time off. So I think this is a policy decision that employers are going to have to consider in 2021. As Chris also mentioned, he talked about the Wage Protection Act rules being amended related to vacation. They have also been amended or will be as of January 1 on a few hyper-technical issues on HIFWA, including the rate of pay for time off for unusual or unique circumstances on call employees or indeterminate shifts. So that's more than we can cover today, but if you have any questions about that or if you'd like a copy of the rule, please let us know. And then finally, the other change that's happened this year on HIFWA is that as written, you couldn't ask for any documentation for somebody who wanted to take public health emergency paid sick leave. In April, CDLE confirmed that you can actually, the employee can take public health emergency sick leave without documentation, but you are permitted to request documentation before you let the employee return in the circumstance where the employee has been out because of their own exposure to COVID. So that makes perfect sense. It's a, return to work safely, I don't have COVID anymore, documentation, and CDLE understands that that is an appropriate ask by employers. So with that, I will turn it over to Ashley.
Thank you, Barb. Very helpful. And I'm going to be talking today about a separate but somewhat related topic having to do with leave in Colorado. And so What I'm going to spend a few minutes talking about today is Colorado's Family and Medical Leave Insurance Program. Only a handful of states have such a program, so Colorado is now joining a very small group. This law just went into effect about a year ago, November of 2020. It's very new. There's still a lot of questions, but we still know more than we did when I presented on this topic the last time. So I'm going to give you some updates. So the way it works is that the Colorado Department of Labor is the one who's administering the program. They've created a new division, and that division is in charge of collecting premiums, deciding what the premium amount will be, determining claims made by employees and making decisions about those claims. There will be an appeal mechanism and so forth. And what this leave is implicating is 12 weeks of paid leave in 1 calendar year, and that's actually a rolling calendar year. It could be up to 16 weeks if there are pregnancy or childbirth complications. So just in case I'm scaring you and you're wondering, oh no, am I already in violation of a rule? The payments for this law do not begin until January 1st of 2023, and then the benefits are available to employees beginning in 2024. So you're not delinquent yet, but it is time to start thinking about what needs to be done in terms of implementation and just putting some policies in place. So overall, a question that's at the forefront of everyone's mind is who is paying for this program? And the way it works is that employers and employees equally pay fees to fund the program. Now, I will say that an employer can, of course, make the voluntary choice to pay for the employee's portion as well, but that's not required. So at a minimum, it's a 50-50 split. And then certainly another question is what events give rise to the leave? And these reasons will look awfully familiar because many of them mirror the exact same language for FMLA leave. So typically it's birth, adoption, or placement through foster care of a child, and then a serious health condition of either the employee himself or herself or the employee's family member. And then there's some additional reasons where the leave may be applicable. It could be for military service leave or to address immediate needs related to domestic violence or sexual assault. Not every employee is covered, and so this is important. So only employees who have worked with the employer for approximately 6 months, specifically 180 days, are covered. And the employee must have earned at least $2,500 in wages. If you are a very small employer out there and you're wondering, am I really going to have to comply with this? The answer is if you have 9 or fewer employees, then you are exempt from contributing. So I thought maybe one way to talk about what we do know is to maybe tell you some of the questions that we've been getting and how we've been answering those. So the first question is, does the employee have job protection while the employee is on leave? And the answer is definitely yes, there is job protection embedded in the statute. You cannot fire an employee who takes a leave or for the reason that the employee previously took the leave. And you also have to restore the employee to an equivalent job upon return. The next question we often get is, how does this all work with the FMLA? Well, the FMLA is for, it can be for larger employers, but for here, those employers that only have 10 to 50 employees, that's really where this law is different for those kind of middle of the road size employers. Also, the FMLA doesn't have the paid component that this process does. And so this is providing actual paid leave for the employee. Also, we get asked, can the employer require exhaustion of accrued vacation leave, sick leave, or PTO first? And the answer is a definite no. That is not something that you, the employer, can require. However, with the FMLA, just like the FMLA, I should say, Intermittent leave is permitted, and obviously that makes things a little bit tricky at times for the employer, but just want to make sure you're aware of that. And is there a cap on benefits? That's something that we're often asked. And the answer is yes. I will say that that's a bit of a complicated issue right now. It's still being worked out, but it looks like for at least the first year that benefits are available in 2024, the initial premium is going to be 0.9% of wages per employee. And then there would be a cap of 90% of the state average weekly wage. That's kind of a tongue twister. And obviously, we don't know exactly what that state average weekly wage is going to be, but we will closer to then, or $1,100, whichever is less. And when I'm giving you these figures, I'm talking about benefits on a weekly basis. So it's going to be that 90% of the state average weekly wage or $1,100, whichever is less per week. And then also employers sometimes talk to us and say, well, we have our own private plan, which provides great benefits to our employees. So do we really have to adhere with this new program? And the answer is you as the employer can choose to use a private plan, but I do have a caveat. You have to be absolutely sure that the benefits being provided to the employee are at least as good as, if not better, than what the employee would be allowed to get under this paid program. And so now the ultimate question, what should I be doing now if I'm an employer? And what I would say is that you need to start thinking about now how you're going to implement this program. You need to have a communication plan. You have to make sure that people within the organization who really need to know and understand the program are communicated with, but you also need to communicate with your employees. They are entitled to know that this program is in place or going to be in place. That's a little bit trickier with existing employees, so you'll have to have meetings or disseminate information to make sure that they understand their rights to benefits. And then with new hires, you can make it part of their new hire documentation or new hire orientation. You need to make sure that your payroll department understands that withholding will need to be made starting January 1st of 2023. And those withholdings are made directly from the employee's payroll. And then most importantly, just stay on top of developments. Ask if you have questions. And there's also a website that's been put up that's actually full of some pretty helpful information. It's famli.colorado.gov. And of course, if you have specific questions relating to your workplace, just reach out and we would be happy to help you. And with that, I'm going to turn it back to Shauna, and we're going to keep the presentation rolling, but with some other topics.
Great. Thank you so much, Ashley and Barb. That was great information. Okay, we have a couple more poll questions for you. The first one is, on average, how much paid leave provided by the Healthy Families and Workplaces Act are employees at your company using? Are they using between 0 to 10 hours, 11 to 20 hours, 21 to 30 hours, or more than 30 hours? So this is just an average of what you've seen since this went into effect this year. We'll give you about 30 seconds to get your responses in. All right, and it looks like we're starting to see some of your responses. It looks like a good majority of those responses are saying that employees are using on average between 0 and 10 hours. Great. All right, we'll move on to the second poll question. How many employees at your company have utilized the supplemental leave provided by the public health emergencies under the HFWA? Yes, no, or not sure. We'll give you some time to enter in your responses. All right, it looks like, so it looks like employees are using that public health emergency leave, about almost 50% there. 13.4% say no, and about 37% are unsure. Great. Well, I think we're ready to move on to our next presentation. We have Chris Otley returning, and he is joined by Owen Davis, and they're going to be providing a 1 year later look at the Colorado Equal Pay for Equal Work Act. So I will turn it over to Owen and Chris.
Thank you very much. Shauna, sorry that you guys have to see me twice here on this presentation, but I'm actually kind of swooping in because our good colleague, Sonia Anderson, was not able to make it today. So given that I have presented on the Equal Pay for Equal Work Act multiple times in the last couple of years, I'm going to do a double duty today to talk first about Section 1. Section 1 is the provision that relates to the actual mandate that both men and women be paid the same for doing substantially similar work. I'm then going to hand it over to Owen, who's really going to have the heavier job here of discussing what it means to under Section 2. Section 2 of the law has to do with job postings, and that's by far generated the most amount of controversy, the most amount of attention, and the most amount of activity in the last year. Nonetheless, let's start off with a refresher. I imagine most of the people on this call are probably already familiar. If they're in Colorado, they understand that the Equal Pay for Equal Work law was passed in 2019. There was a ramp-up period where employers were not required to be in compliance until January 1st, 2021. And it was a law that had some very far-reaching effects. Barb said before that she thought her topic was more important. Yet again, Barb was wrong. It's my topic that's more important, even more important than some of the other importance of Healthy Families Workplaces Act. Here's the thing that everyone needs to understand about the Colorado Equal Pay Law, is that for decades, Colorado was what I would consider to be kind of a mid-tier state in terms of providing workplace protections for employees. Everyone is very familiar with the fact that California has a lot of laws that protect employees in the workplace from various issues. Colorado was, generally speaking, very far behind that. No one was as far advanced as California, but states like Washington and Oregon, New Jersey, Massachusetts, Connecticut, a lot of those states did have laws that provided certain employee protections that you wouldn't necessarily see in other states. Colorado has done everything it can to catch up with California, Washington, et cetera. And in the instance of the Equal Pay for Equal Work Act, they've actually exceeded where California is at in some of the other states. And a lot of multi-state employers are surprised by this law and what some of its requirements are. Not to mention also what the potential liability is. When this law originally passed, I went around giving presentations very similar to this one, and I was convinced that Section 1, the area of the law that mandates equal pay, was going to be the most highly contentious issue, just in general, because I have a good understanding that employers almost never have a scientific formula that they apply to what they pay their employees. So large employers, even sophisticated employers with really good HR departments might have some variation between the pay between different employees, and not at all on the basis of sex necessarily, but just simply because there's pay differentials. And I'll talk through a little bit of that about why that's actually still problematic under the law. But it really was what Owen is going to be addressing a little bit later on that has caught the most attention. In fact, I remember very clearly a phone call with a very long-term HR executive here in town where all she wanted to do was focus on the job postings requirement. So I'm going to do kind of a precursor and then hand it off to Owen so that we talk about it. Now, what are the objectives of the Equal Pay for Equal Work Act? It's obviously to mandate pay equity. It's to limit the exceptions surrounding that. And then it's also to provide the pay transparency through job postings. So really it does fall into these two big sections, pay transparency and pay equity. Section 1 of the pay equity law, and this is the statute as it's written, and it's important to everyone to keep in mind what this means. It says, an employer shall not discriminate between employees on the basis of sex by paying an employee of one sex a wage rate less than the rate paid to an employee of a different sex for substantially similar work, regardless of job title, based on a composite of skill, effort, and responsibility. What most individuals who are looking at this, most sophisticated, whether they be lawyers or HR professionals, look at this, and they see right away that this mandate under this law goes a step further than what the previous existing law was. Because understand, there's already been the Equal Pay Act under federal law since 1965. There has been a provision within Title VII of the Civil Rights Act that says that you can't pay one person more money than you can't pay one individual more than another individual on the basis of sex. That's classic sex discrimination, and that is illegal. The question for the legislature and the General Assembly that they were trying to address with this law was why then, despite having laws like that in effect, and in most states have discrimination laws in effect too, why is it that there are still pay differences between men and women? And if you look to the recitals within the legislation, they cite a lot of statistics that many of us are familiar with, and I don't remember the exact numbers, but it points out that women get paid on average something like 80 cents to the dollar to the men, or that women of color get paid 60 cents to the dollar in comparison to white men. And those statistics are not inaccurate. The one thing I'll make clear to everyone is this law actually doesn't address a lot of the issues associated with that. There is some impact that this law might have, but the reality is those statistics, while used to justify the law, are not actually what the law is focused on. Because the law is not, first of all, equal pay for equal work. That's what it's called, but there's a little bit of mislabeling associated with that. It is equal pay for substantially similar work. I'm sure what everyone is now asking is, well, what is substantially similar work? And the answer is, we don't know. To all my associates out there, you know, I hate it when people use adverbs or an excess use of adjectives. And substantially similar is really difficult to define. So far, the Division of Labor has not even attempted to draft these sort of regulations with respect to that. I believe that they've announced that they don't believe they have the authority to do so. But regardless, right now, there is not a lot of definition of what substantially similar work means. Instead, what substantially similar work is going to be based upon that composite of skill, effort, responsibility. I think this is going to be the most contentious issue once the lawsuits start coming in more frequently. By the way, on that front, there does not appear to be a huge wave of litigation that's popped up yet. So far, we've seen a couple of cases where this law has come up, but we haven't seen anything substantial, for example, from the Court of Appeals, from the Colorado Supreme Court, or even at the federal district court level. So the law went into effect in 2021. Employees do have a private right of action, so they can bring a suit for claims under the law. But so far, we have not seen a lot of guidance from the courts on this issue. That will change, obviously. How soon that will change will really depend upon the frequency of the cases. What do we assume is skill, effort, and responsibility? I think we have a pretty good sense. Skill, obviously, is what are the learned traits that the individual provides to the benefit of the employer. Effort, that's going to probably come down to like how much time the person is putting in, how strenuous is the job. It may also include something related to safety of the job. And then also responsibility. One of the things I always like to bring up, because this comes up a lot in these kinds of conversations, is people want to understand who is substantially similar. And the first thing that they always jump to is as kind of a way of understanding this is how about a comparison between C-level executives? For example, the chief financial officer is almost always going to be paid more than, say, a chief human resources officer. There is a higher proportion of men in CFO positions than there are a proportion of men in CHRO positions. Same thing also for chief legal officer positions. Because the CFO position on aggregate gets paid, generally speaking, more than the CHRO, does that mean that there's going to be, are those two positions considered to be substantially similar? I think generally speaking, we don't believe that they are going to be considered substantially similar because they do have different responsibilities, and arguably they have different skill levels as well. But it seems fairly clear they have different responsibilities. I have no doubt that this is an issue that's going to be litigated at some point. We'll have a little bit more direction, but that's my assumption, is that given that the CFO is really focused on things like the books and understanding the profit and loss statements and the other items that they're actually working on a regular basis, that is different than the human resources officer that's really dealing with personnel. So it's a different skill set. But notice that there's not going to be a great way for employers to defend that, because what the law provides is 6 defenses. That's it. If you are doing substantially similar work to another employee, and that employee is of a different sex, or sex in a combination with some other factor, you are required to be paid the same under this law unless it fits into one of these 6 exceptions. And there is nothing beyond these 6 exceptions. And I'll briefly go through each of the 6. First is the seniority system, and that is as you would expect. By the way, the first 3 come straight from federal equal pay law. We have good direction on what is a seniority system. Seniority tends to be more than just tenure with the company. It can also be the amount of time that the person has been in their chosen profession or their job, so that they might merit more pay. It's a really easy thing, for example, during audits for us to do a comparison on. A second system is going to be the merit system. The really good question that Barb Grandjean and I have spoken about multiple times is how closely tied is this going to be to performance evaluations? You can have a pay differential between 2 employees doing substantially similar work, and you can justify a pay differential based upon a merit system, but it better be reflected in the performance evaluations. If there's a performance evaluations that seem substantially similar, later on an employer is going to be very hard-pressed to be able to explain why one employee gets paid more than the other. A third system is the system measuring quantity or quality. That one's fairly straightforward. It frankly relates a little bit back to the first question of whether they put in the same amount of effort. The next 3 items were items that were during the negotiation of this legislation down at the General Assembly. Those were added, and they were kind of created from whole cloth. The question was, can you have a differential in pay by location, education, or travel? Location makes the most sense. Obviously, someone who's working in downtown Denver has a higher cost of living, and perhaps there's a need to have a higher paid employee who's working, for example, at a grocery store than maybe there's a person who's working at the grocery store in Greeley or Pueblo or out on the Western Slope. Just because of market forces, that might be a justification for a pay differential between 2 substantially similar individuals. Education, I think, goes without saying. And then finally, travel. I suspect travel is one that's almost going to be a throwaway. I said before that we've obviously had equal pay laws in effect for a very long period of time. How is it that the Colorado law separates itself from, as far as I know, every other equal pay law in the country, including in states like California, New Jersey, Washington, Connecticut, et cetera? It's its omission of this next defense that comes under federal law, and some provision of it is under other laws. So in the state of Colorado, it is no longer okay for an employer to justify a pay differential to 2 employees doing substantially work based on a differential based on any other factor other than sex. That's huge. That catch-all, any other factor other than sex, might have made sense up until the year 2021. Any other factor other than sex takes into a whole range of other factors. There might be legitimate business reasons for why the company was paying people differently on that basis. However, in this circumstance, in Colorado, you can no longer rely upon that. And because it's no longer a defense, you got to fit it into one of those 6 specifically enumerated exceptions. For those of you who are wondering, well, why wasn't that exception included in the Colorado law? The Defense Employment Bar, the business community advocated for it, and it was dead on arrival. The advocates in favor of this legislation flat out said not a chance. And frankly, it's one of the reasons why they included those bottom 3 exceptions, was because that was kind of the bone they threw at the business community to say, well, why don't you identify for us what you think is okay and where we're going with that. So this law has some real teeth. As I mentioned before, there's a private right of action. It is it is in effect a strict liability statute. As I mentioned in my earlier presentation, whenever we're dealing with wage and hour law, we don't have a good faith defense. I don't believe there's going to be a good faith defense. I think that there's some members of the defense bar and other groups that are going to try to argue that there's good faith defenses for differentials between pay between men and women. I don't think that's going to work out. One of the most frequent questions I received is, does this work both ways? In other words, can you have a reverse discrimination claim? Absolutely. There's no question at all that under this law, both men and women can cite an example of another employee who's getting paid more. I frequently have received questions from federal contractors where they talk about the statistical methods that they've used to say that they're in compliance with pay equity laws under federal contracting statutes, under the federal contracting statutes. I don't see that as a likely answer or a likely defense. I think the statute means what it says, and it says what it means. And what it means is if you don't fit into one of these six exceptions, you're not going to be able to justify a pay differential between 2 different employees of different sexes. Owen, I'm going to hand it over to you to talk about the area of the law that has received the most attention. Section 2.
Thanks, Chris. So as Chris mentioned, while the pay equity rules are what got a lot of attention before the act went into effect, it's really the transparency rules that we've gotten the most questions and issues from clients about. That said, HR managers were quick to identify the challenges that the transparency rules would create for employers, which have turned out to be true with the act now into effect. Essentially, employers now have to micromanage the job posting and hiring process that used to be much easier and quicker and painless. To be sure, Colorado's law is probably the most onerous job posting law in the country. Other states have considered or passed similar laws, but the laws actually enacted usually require employers to take action upon, a request from an applicant. In contrast, Colorado's law is compulsory. It requires employers to take affirmative steps to stay in compliance. So as a refresher, the transparency rules basically boil down to two requirements. First, an employer must make reasonable efforts to inform all current employees of any promotional opportunity. And second, employers must disclose salaries and descriptions of compensation and benefits in any job posting. So what does this mean? Well, from those two sentences, the CDLE has issued approximately 30 pages of rules and guidance as to what those two requirements actually require. Clear as mud, I know. But while they have provided some direction that I'll get into in this presentation, it's obviously raised a lot more questions and confusion for employers. As you'll see here in this slide, after the initial rules and law went into effect, the CDLE revised its guidance in July of this year, and then also issued a notice letter in July as well regarding compliance under the transparency rules that I'll touch on in a moment. So again, what is a promotional opportunity under the first requirement? According to the equal pay transparency rules, a promotional opportunity exists when an employer has or anticipates a vacancy in an existing or new position that could be considered a promotion for one or more employees in terms of compensation, benefits, status, duties, or access to further advancement. Again, it's important to note what the actual language says, because as you can see, it pretty much applies where any employee would consider the position a promotion, which is expansive. And then you also see that a vacancy in a quote unquote existing position occurs when an existing position that the employer intends to fill is open or is held by a departing employee, while a vacancy in a new position occurs when an employer adds a position or gives an existing employee a new position, including by changing their title or materially changing duties. Obviously, again, this is very expansive, and we understand how confusing this is and how many questions it raises. It requires a complete change of mindset into the hiring process and job posting process, which used to be much more easy. So there are three exceptions under these transparency rules, but you should note that they are much more limited than they appear on their face. So first, we have this confidentiality exception, but note that it applies only where the to-be open position is held by an incumbent employee who is not yet aware that they will be separated. Obviously, this would not arise or apply in a lot of common like transition and succession plans where the employee knows that they are stepping out. And I know we've had issues with that with certain clients already come up. The second exception on the screen is the automatic promotion after trial period exception. But this only applies following a trial period of one 1 year or less, and the commitment to consider the employee for promotion is set forth in writing and based solely on the employee's own performance and or the employee's, the employer's needs. Again, this exception, it means that it does not apply to most automatic or inline promotions. For the final exception, the temporary acting or interim hires exception, this applies only where an employer fills, and I'm going to quote the language here, a position on a temporary basis for up to 6 months where the hiring is not expected to be permanent. For example, an acting or interim position. Again, that's much more restrictive than you might think. And note that once the hire may become permanent, then the employer is required to comply with the job posting requirements. So what information is required in the job postings? A lot of issues spring up from this, obviously. As to the information required for any posting, this includes the rate or range of compensation, a general description of any bonuses, commissions, or other compensation, and a general description of all benefits the employer is offering to the position. Now, jumping to 2 and 3 first, thankfully, the CDLE has clarified that the description of benefits does not need to be too onerous. Generally, a brief general description of what benefits are provided would be sufficient. So, for instance, posting that a position comes with health insurance without setting forth the premium costs or the coverage specifics is okay, according to the CDLE. The CDLE has also further excluded minor perks that might come with a specific job, like on-site gym or, or discounts that you might get through your employer. All that said, employers cannot use open-ended phrases such as "and more" or "et cetera" when describing the benefits offered. So please keep that in mind as you're putting together your job postings. Now, the big piece of information that raises a lot of concern is salary. Obviously, employers are sensitive about posting salaries in job postings. Now, according to the CDLE, a posted compensation range may extend from the lowest to the highest pay the employer in good faith believes it actually or genuinely believes will be paid for the particular job. Now, what does good faith actually or genuinely believes mean? We're not fully sure either. It's really determined on a case-by-case basis, and it has definitely caused a lot of problems for employers. So please don't hesitate to reach out if you have a question about as to what the range can be. As you can see from the slide, also note that open-ended phrases here when it comes to salary are also not allowed. $30,000 and up or up to $60,000. Again, like I said, after hire, an employer may pay more or less than the posted range. But again, what you post is what you actually believe, genuinely believe, and in good faith believe that you will actually pay the position once it's filled. So almost a year into this experiment, what has happened? Well, the biggest controversy around the transparency rules this year is what you see here on the screen. Colorado made national news, but not for the best reasons. Employers across the country started posting jobs and hirings, but noting that Colorado applicants would not be considered. And I don't know if you can make out the text on your screen, but you can see specifically on LinkedIn and employer websites, they said essentially Colorado applicants need not apply. So the CDLE responded to this in July with the notice I referenced earlier. As you can see from the slide, the CDLE noted that it has received numerous complaints that remote job postings lack required pay disclosures and exclude Coloradans from consideration. In this notice, the CDLE basically reinforced that posting requirements apply to jobs for either work tied to Colorado locations or remote work performable anywhere, but not work performable outside of Colorado, but not work only performable outside of Colorado. And the very helpful example they give us here is a wait staff at a restaurant, not in Colorado. Obviously, it's not very clear, what specific jobs would be limited, tied specifically to Colorado, given that people will work for employers all across the country, and especially with COVID this past year, the amount of remote work has expanded enormously. Again, though, as a good reminder, the law only applies to employers who have a Colorado employee. So again, a New York company that has no Colorado employees, if they're posting for a remote job that can even be worked anywhere, they do not have to follow, based on our reading of the statute and rules, they do not have to follow these posting requirements. That said, again, with COVID, people are starting to work all over the country. Some employers might not even know where some of their employers are working remotely. They may have moved to Colorado for our beautiful weather and mountains during the pandemic. And once they're here, then by the letter of the law, the employer, even based in New York, has to comply with the job posting rules. Now, this raises a big question as to exactly how will this be enforced? So this notice letter that the CDLE issued in July indicates that, at least for right now, the department is more interested in educating employers than punishing them. Now, obviously, this might change, but again, it's unclear how this can be enforced, especially for out-of-state employers. How will the department know that an out-of-state employer has 1 or 2 employees living in Colorado and is therefore subject to these posting requirements? And how can they review each and every posting requirement that goes on LinkedIn, all over the internet? So there's a lot of unanswered questions left there. And again, like it says here in the
Okay, sorry for the technical difficulties. We not entirely sure what just happened there, but I was told right when I was getting my head of steam and getting ready to go off in the CDLE that we lost our feed. I think that's an example of how much power the CDLE has and that they weighed in on this issue.
It's the increased budget.
Yeah, exactly. Yeah, that's what the investigators' budget was. So. Just to tie off a point, and then I'm going to ask Owen to actually talk a little bit about a recent federal court challenge to this law. My point on enforcement that I was making beforehand was that the employees don't have an individual or private right of action on this particular law. That portion of the law, excuse me, so just Section 2 job postings. And so really it's just an administrative task right now. I do believe that as we work through all these issues, as the law becomes more widely known, that there's going to be a little bit more teeth to what the CDLE is attempting to do. I suspect that right now, most violations that we're seeing from the CDLE are really just kind of either slaps on the wrist or just a warning or just an informational type of effort. I think that's the exact right approach, in case you're wondering about kind of where I stand on that, is that just a lot of employers are surprised by this. And as a result of that surprise, they aren't aware that they, for example, are required to make a promotional decision known to everyone within the company. Private companies in particular really hate sharing that pay range in the job postings. That's the thing that they hate the most. The reality is that is exactly what the law was intended to do, was to require employers to provide that pay range. That's the transparency component to it. Owen, would you mind taking just a little bit of time and explaining the recent federal court decision that was a trial court decision that addressed the constitutionality of this law?
Sure, of course. So like Chris said, there has not really been that much litigation around the act in general, at least at the higher level courts that we've seen. The one exception being that there was a case in the Federal District Court of Colorado that began, I believe, at the start of this year, right when the law went into effect, where a trade organization of job recruiters filed a lawsuit against the department seeking to enjoin enforcement of the transparency rules. And that they basically argued in the case that the transparency rules violated the Dormant Commerce Clause and free speech protections, specifically commercial free speech protections. Over the summer, Judge Martinez at the district court issued a decision denying the preliminary injunction, basically finding that there wasn't enough evidence at this time to say that there was a clear violation of either of those. So they denied the he denied the injunction, and then plaintiffs dismissed the suit. So that case is no longer ongoing, and now it's just a question to see, as this continues to roll out, how it applies to employers, what they have to do in response, whether more litigation will result, which I think is fair to say will.
Yeah. Thanks, Owen. And by the way, Judge Martinez, for those of you who aren't aware, his background was he was a member of the Plaintiffs' Employment Bar. He had been, I believe, I forget if he was the regional director or chair of some sort of within the EEOC. They couldn't have gotten a worse judge draw. And I have a lot of respect for Judge Martinez. I think that his decision was very well reasoned, and he really addressed the very difficult issues. But nonetheless, it does just kind of go to show how it would have been very difficult to have had that challenge prevail. That being said, so now what are employers required to do? Again, the law is in effect right now. There is no waiting period to get into compliance. I can't think of a better way to do to get into compliance than conducting an audit. When I mean by audit, I don't just mean like an audit of your job postings. That's actually not going to be very difficult for you to do, or for you to send to your outside counsel, hopefully us. We can do that in really short order. What I mean by an audit is actually doing an audit with respect to Section 1 and doing a cohort analysis that compares men and women who are doing substantially similar work throughout the entire organization. And I've done probably close to almost a dozen by now. And I'll say, regardless of whatever my personal views are on this law, I will say the audit process is a really good process for companies to go through. I do recommend you do it through outside counsel. You want to have the privilege. A lot of companies are choosing not to do that, and I understand, because they don't want to make the expense. Nonetheless, the audit process is really valuable, because when you are comparing individuals based upon what they're paid and based upon all the rules that we looked at in terms of the exceptions, it is helpful just to identify why it is someone is getting paid more than somebody else. And inevitably, there is at least a couple of positions where you ask the question and the answer is always, well, maybe that's because the previous hiring manager always wanted to hire at the 80th percentile rather than the company's 60th percentile or 50th percentile policy. That's not an excuse any longer. That's not an excuse any longer. Or maybe there's, for example, a hiring bonus that's paid because the market is so tough to identify people. Hiring bonuses are really hard to justify under this law. I didn't go through it under Section 1, but if you think about what are all the rules for substantially similar work and those 6 exceptions, a hiring bonus, in other words, kind of economic reality is giving someone to leave their old job and come join you, is not a justification for a differential in pay. And it doesn't matter whether it's a man being hired or a woman being hired, if they're being paid more, and assuming the strict liability applies, that's likely not defensible under the law. These audits are a really good way to provide the level of scrutiny that you can do internally rather than having plaintiff's counsel or the Division of Labor doing it for you. So remaining kind of things to do, obviously, watch out for the court decisions. Again, I'm assuming we're going to start to see a lot more court decisions because the law has only been in effect for about 10.5 months so far. And given the backlog that most cases have, it's not surprising to me we haven't seen a lot of decisions on this yet. Regardless, do expect that we're going to get a little bit more clarification and definition on some of the issues that we're talking about, particularly what does substantially similar mean? What do some of those exceptions, how do they play out? Thirdly, you're going to want to make sure that you're addressing this issue proactively. Have a policy in effect now. If you're not going to have a policy because you just don't like to have a policy, have a protocol in effect, in play right now where you're asking yourself, when somebody gets paid X, how do we pay somebody else? It's a different mindset. Same thing with the job postings. Make sure that the people who are in charge of putting up job postings, whether it be on an intranet or on a company bulletin board, make sure that those are compliant with the law now. It's going to be much better to address these issues early rather than having that letter come in from the Division of Labor or have employees starting to complain about it. And finally, just to give everyone some assurance, this law is so dramatic, a lot of really good companies are doing their best to comply, and they're doing so in different ways. There is no question that some companies have higher risk tolerance, have different underlying situations, might be trying to decide whether or not separately incorporated entities are going to be included within the employee pool. It has to have job postings made. All of these are issues that keep coming up. Do your best. Even if there's not a good faith defense, do your best. Do whatever you can at this point to be able to justify and to show that you've made your best effort to comply with a law that's fairly complicated. I assure you in the long run it's going to work out, particularly if we start dealing with the Division of Labor. They're going to want to know that you're one of the employers that took this seriously rather than an employer who either stuck their head in the sand or claimed willful ignorance. With that, unless there's anything else.
I was just going to note, too, that the notice I referenced earlier in July, the CLE specifically said, if you have questions about a particular job posting that you have, you can contact them. So that might be a way to kind of create that bridge with the department.
That sounds great. That sounds great. Okay. Well, thank you very much. This is obviously one of my favorite topics to talk about. Shauna, back to you.
Great. Thank you, Chris and Owen. All right. We have one last poll question, and I think this is the big one. Do you think the equal pay transparency rules and practice have promoted equal pay? Yes or no? And we'll give you just a little time to respond to that. All right. So we've got answers coming in, and it looks like about 42% say yes, and 57% say no. All right, now we're going to move over to recent legislation, labor and employment legislation here in Colorado. First up is the Veterans Hiring Preference. This is House Bill 21-1065. This bill was signed on June 23rd, 2021 by Jared Polis. It allows private employers to create a veterans preference in hiring when the hiring is done for an eligible individual and that individual is qualified as other applicants. To adopt a veterans preference hiring policy, an employer must apply the policy uniformly to all hiring decisions, require that the veteran provide proof of service, require when it's a spouse of a service member killed that they furnish proof of marriage, the spouse's discharge documents, and a death certificate. And the policy must be in writing, public, and implemented at least 14 days before a job posting or hiring decision is made. Persons qualified for this preference include veterans who have a 100% permanent and total disability rating and were discharged from service within the last 10 years before the hiring. Veterans who have less than 100% permanent and total disability rating and were discharged within 5 years prior to hiring. Similar to number 2, for members of the military reserve and National Guard members who have less than 100% permanent and total disability and were discharged within 5 years of hiring, and spouses of service members who were killed in the line of duty within 5 years of hiring. The adoption of a veterans preference hiring policy creates a rebuttable presumption that the policy is not discriminatory or an unfair employment practice. Private employers are not required to have these policies in place if they are actively recruiting veterans. And this went into effect September 13th of this year. So you may be asking yourself, why is a veterans preference policy necessary? You might think that there has always been a veterans preference, but a veterans preference is necessary because without one, you could run afoul of Title VII. If you take a look at the EEOC policy guidance provided on veterans preferences, they provide different reasons for why a preference is needed to not run afoul of Title VII. And this comes from a long-standing history of federal statutes, regulations, and policies that exclude women or sharply limit women's eligibility to serve in the armed forces. It's also based on the fact that women have never been subject to a military draft, and only a small percentage of women are veterans are women. So consequently, any veterans preference policy is going to overwhelmingly be an advantage to males. So Title VII does provide this exception that says nothing contained shall be construed to repeal or modify any federal, state, territorial, or local rule creating a special right or preference for veterans. So this is where the Colorado state preference comes into play and allows employers to use that preference policy and not be concerned that they're running afoul of any discrimination laws. The next bill we're going to talk about is the Gender Identity Expression and Anti-Discrimination Act, House Bill 2011-08. So as most of you probably know, the Supreme Court in June of 2020 decided Bostock versus Clayton County. And in that case, the court determined on a discrimination on the basis of sexual orientation basis of sexual orientation includes gender identity because of sex. So following the Bostock decision, several states have broadened their prohibition against discrimination, including extending their discrimination statutes to include a prohibition against gender identity and gender expression. So Colorado is joining that list of states that have made this change. In May 2021, the House Bill 2011-08 was adopted. This now prohibits discrimination on the basis of gender expression and gender identity, and amends the definition of sexual orientation in 48 different laws. This covers employment practice laws such as the Colorado Anti-Discrimination Act, housing practices, places of public accommodation, financial services, healthcare, and many more. Like I mentioned, there's over 48 different areas of law that are impacted by this change. So prior to this act being enacted, the protected classes for discrimination in Colorado were disability, race, creed, color, religion, sex, sexual orientation, age, national origin, ancestry, and marital status in limited circumstances. So we add to that list now gender expression, which means an individual's way of reflecting or expressing the individual's gender to the outside world, typically demonstrated through appearance, dress, and behavior. And we add gender identity, which is an individual's innate sense of the individual's own gender, which may or may not correspond with the individual's assignment of birth. And then sexual orientation is modified to include identity or another individual's perception thereof in relation to gender or genders to which the individual is sexually or emotionally attracted, and the behavior or social affiliation that may result from that attraction. So this act went into effect on September 13th of this year. So next, we're going to look at House Bill 2011-88. And this is regarding additional liability under respondent superior. So this bill was signed in May 2028, and it was a law specific to adding additional liability for any employers who admit employee fault under the doctrine of respondent superior. Respondent superior is a legal doctrine most commonly used in tort that holds an employer or principal is legally responsible for the wrongful acts of an employee or agent if such acts occur within the scope of employment or agency. In 2017, the Colorado Supreme Court decided the Frerer case. That case held employers who admit fault of an employee for negligence would not be subject to any further direct action by an aggrieved party, and recovery was drastically limited. This limitation reasonably resulted in simplification of litigation involving employers for employee conduct, since recovery was limited solely to what could be recovered from the negligent conduct of the employee. So courts also refused to allow aggrieved parties to argue employer conduct as a basis for punitive damages, and punitive damages were limited to the conduct of the employee alone. So this new law was put into place expressly to overturn this decision. This act now provides that when an employer or principal acknowledges vicarious liability for an employee or agent's negligence, a plaintiff's direct negligence claim against the employer or principal is not barred. So this means a plaintiff can bring claims in conduct associated with discovery in addition to claims in discovery based on respondent superior. And this went into effect September 7th of this year. So next up, we have the elimination of subminimum wage employment, and this was Senate Bill 20-039. So current law allows employers who hold a special certificate from the Department of Labor that authorizes the employer to pay less than minimum wages to employees who are impaired by age, physical or mental disability or injury. This bill was put into place to phase out the subminimum wage employment and requires that all employers establish plans to phase out subminimum wages by July 1st of 2025. So the purpose of this act is to eliminate subminimum wages is to promote economic justice and enhance self-sufficiency of individuals with disabilities while ensuring those individuals have an integrated transition plan that allows them to transition into different employment or other integrated community activities that support that individual's goals. So some of the details of the bill are: it eliminates sub-minimum wage discounted by 15% to persons certified to be less effective due to physical disability. Those employers that employ such individuals on sub-minimum wage must report to the Department of Healthcare Policy and Financing on the number of individual and hours that fall under this category. Those employers are to create a transition plan due June 30th of 2022 with a complete transition out of some minimum wage by July 1st of 2025. So the HCPF will work with employers to go through this transition plan And this act went into place July 1st of this year. And last, we have the Agricultural Labor Rights and Responsibilities Act, which is Senate Bill 20-087. Historically, farm workers have been excluded for different labor laws and protections. Many of these exclusions still apply. So the agricultural workers' rights law is targeted at improving the working and living conditions of Colorado farm workers. This act prohibits an agriculture employer from retaliating against persons. It allows aggrieved persons to assert a claim either in district court or with the Colorado Department of Labor and Employment for any alleged retaliation. It grants agriculture workers the right to organize and join unions, which they did not have before, and establishes a separate minimum wage for agriculture employees engaged in specifically range production of livestock on the open range. This act also requires that the CDLE establish overtime pay for agriculture employees, to implement procedures concerning retaliation claims, to ensure access to key service providers, and for overtime protections. It removes the different exemptions for state and local minimum wage and overtime pay, and specifies overwork and health protections to be offered to these employees. This act went into effect June 25th of this year. The CDLE was also tasked with creating agricultural labor condition rules, which were published on October 29th of 2021. If adopted, these rules will go into effect May 1st of next year. And these rules address things like key illness and injury protection, access to key service providers, communication access to offsite providers, and enforcement of retaliation. These rules are available at the website provided. There will be a hearing on these rules on December 9th, and comments are allowed until December 20th. So that is the end of our program. Thank you for joining us today. We hope this was helpful for you and your organization. As a reminder, this program has been approved for HR and legal education hours. To report your hours, click on the CEU icon at the bottom of your screen. A certificate of attendance, including the course number, will be emailed to you tomorrow, along with a recording of the webcast that you can watch and also share with others. Please be sure to complete our short survey. We use your feedback to plan for future programs that are applicable to your business needs. And that concludes our program. Thank you once again for joining us.